Hello. The focus of this video is civil liberties. Civil liberties are the constitutional rights that Americans have that are listed in the Constitution, and specifically you can find them in the Bill of Rights. Now, the original Constitution written in 1787 did not actually contain a Bill of Rights. A lot of the opponents of the Constitution thought that was a problem because they noted that the Constitution gave a lot more power to the central government than it had under the Articles of Confederation, which was our first Constitution. And so, since the original Constitution did not contain a Bill of Rights, these opponents, the Anti-Federalists, said that the state should not ratify it. So the proponents of the Constitution, the ones who wanted it passed and ratified, who were known as the Federalists, pledged that if the states would ratify the Constitution, they would make sure that Congress adopted a Bill of Rights and added it as amendments to the Constitution once it went into effect. And that is, in fact, what did happen. So the first 10 amendments to the Constitution, which were adopted in 1791, 2 years after the Constitution went into effect, are the Bill of Rights. And you can find them listed in Chapter 4. They deal with our freedom of speech and religion and the press, which is the First Amendment. There are constitutional rights and liberties that we have when we're accused of a crime, which you can find in the 4th, 5th, 6th, 7th, and 8th Amendments, and then a few other rights that are listed in the Bill of Rights. Now, the concern that people had was not about the states taking away people's rights. They were really more concerned that a more powerful central government, the federal government, would be taking away people's rights, and that's why the Bill of Rights, as originally written in 1789 and then adopted in 1791, actually only applied to the actions of the federal government. They did not apply to the actions of the states. The very first word in the First Amendment to the Constitution is Congress. It begins with the words, "Congress shall make no law," and then it refers to the limitation on Congress's power over our freedom of religion and the press and speech and things like that. So the basic understanding for the first 80 or 90 years of American history was that the Bill of Rights only applied to the actions of the federal government, not of the states. Now, this is something to think about because most of the laws we live under in this country are not federal, but state. Everything from public safety, like the speed limit that we have to follow when we're driving, or other issues that we face on a daily basis, all the way up to murder. Almost every crime that we can think of, almost every law that we have to follow is a state law. So if you consider that a lot of the Bill of Rights deal with our rights to freedom when we're accused of a crime, the so-called rights of the accused or the due process rights, there's a much greater likelihood that if a person is being charged with a crime, they're being charged at the state level, not at the federal level. And yet, for the first 100 or so years of our Constitution, the constitutional rights that we have in Amendments 4 through 8 really didn't apply at the state level. So the right to a lawyer, which is the name of the Constitution is right to counsel, legal counsel, freedom from unreasonable searches and seizures in our home, so a basic right to privacy, the freedom from double jeopardy, the idea that you can't be tried twice for the same crime, and a number of those other rights, which are very fundamental to due process in the United States, only applied to actions of the federal government, not of the states, until the middle of the 19th century. But that was a major issue because, again, most crimes are prosecuted at the state level. And the First Amendment rights did not apply at the state level, and all the others did not either. Now, some states actually did have rights listed in their own constitution. Certainly, every state today even has a kind of a Bill of Rights of some kind, so that would apply rights to the states. But for many years, the federal Bill of Rights only applied to the actions of Congress. That began to change after the adoption of the 14th Amendment to the Constitution. The 14th Amendment to the Constitution was adopted in the years after the Civil War. It was one of the so-called post-Civil War amendments. The 13th Amendment abolished slavery. The 14th Amendment dealt with due process and equal protection of the laws. It essentially established citizenship rights at the state level. which did not really exist before then. And then the 15th Amendment guaranteed the right to vote to people regardless of race. Those three amendments were passed in the 5 years after the Civil War ended as a way to extend rights to the freed slaves. So for many years, the 14th Amendment, which is the one that's important for due process and civil liberties, it said that people had citizenship rights at the state level. It said that people were entitled to due process of law. That concept of due process is in the Fifth Amendment to the Constitution. It says you can't be deprived of your life, liberty, or property without due process of law. And that same language is in the 14th Amendment. Now, the 14th Amendment, again, the Fifth Amendment applies to federal actions, whereas the 14th Amendment applies to the states. But up until the 1930s, so for the first 70 or so years after the 14th Amendment was added to the Constitution, it didn't actually extend the Bill of Rights to the states. It only just said that that you had due process rights, and the Supreme Court, which is important, which is involved with deciding what our rights mean, was not willing to extend the Bill of Rights to the states. But beginning in the 1930s and really accelerating in the 1960s, the Supreme Court began to incorporate provisions of the Bill of Rights into the 14th Amendment so they could be applied to the states. So remember that the Bill of Rights applied in language only to the federal government. The 14th Amendment says we have rights at the state level. The language that links those two is the concept of due process of law. And so essentially what happened after the 1930s and 40s is the Supreme Court was willing to say that due process in the 14th Amendment included various provisions of the Bill of Rights. So things like the right to legal counsel in a criminal case, the right against the freedom from double jeopardy, the right to a speedy trial, all of those basic rights that people have when they're accused of a crime have been incorporated into the 14th Amendment and now actually do apply at the state level. That's the process of incorporation, or sometimes called selective incorporation, which is discussed in your reading. And just the idea is that the Supreme Court over time changed its interpretation of what the various provisions of the Bill of Rights meant, because the 14th Amendment says you're entitled to due process of law. And so the Supreme Court said, well, what do you need in order to have due process of law? Do you need to have a lawyer to defend yourself? At a certain point, the Supreme Court said yes, that if you don't have a lawyer to defend yourself, you can't have due process. So that right to counsel now is considered to be part of due process in the 14th Amendment, which means that it can now be applied at the state level. And everybody in every major criminal case in the country does have a right to legal counsel, not just at the federal level, but also at the state level, which is really where it's even more important. And there's a whole host of those rights that are listed, and just check the chart in your book, because it kind of goes into what the right is, which amendment it involves, and what the name of the case was that incorporated it to the states. And that's very important because, again, it between really in the 1960s, which was a period when there was a Chief Justice who was really more progressive, more liberal on civil liberties issues and civil rights issues, Earl Warren. It was during that time period that the Supreme Court was most aggressive, most assertive in incorporating the Bill of Rights into the 14th Amendment so that they could be applied to the states. So make sure you do read those about those cases in your book. The other topic related to Chapter 4, dealing with civil liberties, I wanted to mention is the idea of the First Amendment rights, which are freedom of speech, freedom of religion, freedom of the press, and the right of people to assemble. Again, there are a number of cases that came out of the Supreme Court over the years, many cases over many years, that have kind of laid out what exactly does freedom of speech mean, or freedom of religion, or freedom of the press. Every right we have in the Bill of Rights is limited to some extent because you cannot infringe on someone else's rights. So an example is with freedom of speech. I have the right to say what I believe. That's protected by what's known as the Preferred Freedom Eminent Lawless Action Standard, which the Supreme Court came up with in the 1960s. So you do have the right to say what you believe, but you do not have the right to threaten bodily harm to another person. That is not protected by the First Amendment. So there is a line between, your expression of your beliefs, and the line is that going to infringe on or hurt someone else? The First Amendment also doesn't mean that you can libel or slander someone. You can't say something about another person that isn't true with the intention of harming their reputation. You don't have the right of what's called obscenity, or obscenity is considered to be a violation of the First Amendment. So that usually obscenity is defined as something that has a sexual content to it and is not designed for any artistic or political or scientific purpose. And so that's discussed in your reading. So there are limitations on the First Amendment, but political speech is very broadly protected. Your right to say what you believe is broadly protected. Again, as long as you're not harming someone and keeping in mind some of those other limitations. There have been a number of cases over the years where the Supreme Court has kind of had to interpret exactly what does it mean to say you can say what what you believe. Freedom of religion, again, the idea that you have the right to practice your religion, which is free exercise. You cannot be restricted in that unless your religious exercise harms someone else. And then the Establishment Clause, which basically says that the government cannot favor one religion over another. And this is why faculty-led or school-led prayers are not allowed in public schools, because that is favoring one religion over another. And then there's the issue of the right to privacy, which is discussed in your reading. It's not a right that's specifically listed in the Bill of Rights, but it's understood as coming from the various provisions of the Bill of Rights. So, for example, the freedom from unreasonable searches and seizures in the Fourth Amendment. The understanding from that is that the police, if they want to come into your home to search for evidence of a crime, have to have a proper search warrant, which they get from a judge. Or they have to have probable cause that something illegal has happened in your home. But that means you have a fundamental right to privacy. If they don't have probable cause, if they don't have a warrant, they can't just barge into your home. So that's a right to privacy. Your right to your own beliefs, that's a right to privacy. There are a number of provisions of the Bill of Rights that give us a right to privacy. And so the Supreme Court has asserted over the years that people do have a constitutional right to privacy. That right to privacy has been extended to a number of areas, including decisions about contraceptives, which is the right to for couples to be able to use condom or birth control pills, things like that, which the Supreme Court at one time there was a time when that was not protected, and there were some states where it was illegal to even purchase condoms and contraceptives. But the Supreme Court said that's a violation of the right to privacy. That has also been applied in the case of consensual sex between adults, and it also applies to the right to abortion. In a 1973 Supreme Court decision, Roe versus Wade, the Supreme Court said that women have the right to decide on abortion based on their fundamental right to privacy. Now, that is a right that could be limited in coming years, depending on what happens in terms of Supreme Court appointments and things like that. As the Supreme Court moves in a much more conservative direction, it's possible that right could be curtailed or eliminated altogether, but currently it still does exist. So, at any rate, please make sure you read Chapter 4 very carefully. A lot of cases are discussed, but I just wanted to give you some background on civil liberties, and in particular some of the rights that we have that are guaranteed by the Bill of Rights, and how the Supreme Court has interpreted those over the years. But just understand that most of the provisions of the Bill of Rights, from the First Amendment through the Due Process Amendments, are now incorporated into the 14th Amendment and are considered to be, they have to be applied also by state governments, with a few exceptions, but most of them do apply. So, hope all's well. If you have any questions, send me an email or leave me a message. And hope all's well. Take care.